Well, hello. Welcome everybody to this one of our webinar series with Aaron's and partners who are our legal representatives. And my name's Claire Bottle. I'm the Chief Executive of the UK Warehousing Association. We're delighted to be presenting these webinars. And today we're going to hear about TUPE, an area of the law that is often quite important in logistics. And I'm really glad that we've got an absolute expert in the shape of Michael Redston here from Aaron and Partners, who's going to talk us through the rules associated with TUPE. So over to you, Michael. Thank you very much.
Thanks, Claire. Good morning. So I will just quickly share some slides with you. So today I'll be talking about TUPE. It's part of the Bitesize briefings that we're doing, and so it will be a whistle-stop tour of TUPE. I've chosen particularly to focus on service provision changes as the type of relevant transfer that's probably most relevant to the kind of work that goes on in the warehousing logistics sector. So what is TUPE? The Transfer of Undertakings, Protection of Employment Regulations 2006, and the title itself covers some of what it means. Where there is a transfer of undertakings, employees' employment is protected. It's derived from an EU directive, and I'll talk about that a little bit at the end. It is still it will still continue to function even after Brexit, after we've been out of the EU for a while now. It is designed to protect employees if the business changes hand, and it is only employees, so it doesn't apply to workers or to self-employed contractors. Worker status is a whole other webinar we could do for a couple of hours. But if you had any questions about whether someone's a worker or an employee, then get legal advice. The effect ultimately is to preserve an employee's terms and conditions so that they transfer over and their employment is not affected. So just a very small bit of jargon. The transferor is the original employer and the transferee is a new employer. Now, I'll talk in a minute about the two types of transfer. With a business purchase, then the transferor is going to be the seller and the transferee is the buyer of the business or the assets of the business. In a service provision change, it's a bit different. It'll be either the outgoing contractor and the incoming contractor, or the client who's now contracting out their services, for example. So first question for TUPE is, what is a relevant transfer? There are two types. The first is a business transfer and the second is a service provision change. Now, I won't focus on business transfer today. As I say, I think the service provision change is probably more relevant, but as a very quick rundown, the test really is whether an economic entity has retained its identity. So there must be a transfer of an economic entity. And the economic entity must retain its identity after the transfer. In many cases, this is simply where a business is bought up wholesale and continues as a going concern. In other cases, it may be that only assets are purchased, where it won't apply as to a share sale because the business still exists as it was and it's only the owners that's changing hands. But more importantly for today is the other type of relevant transfer, a service provision change. Regulation 3(1)B sets out essentially the three types of service provision change you're going to see: outsourcing, subsequent outsourcing, or changing from one contractor to another, and insourcing. So essentially, TUPE will apply when activities carried out. Regulation 321 confirms that activities carried out after the transfer must fundamentally be the same as those carried out pre-transfer in order to fall under the definition of a service provision change. So essentially, it needs to continue the same contract type. The same activities under that contract will continue when contractors are changed or when the services are outsourced, for example. And then I think that probably the most important one that's focused on that needs to be focused on really for your attention is Regulation 3A1. Is there an organized grouping of employees situated in Great Britain, which has as its principal purpose the carrying out of the activities concerned on behalf of the client? So just in terms of it being situated in Great Britain, it can be a transfer out of the UK, out of Britain, but the company that the transferor company and their work needs to be transferring from Great Britain or within Great Britain. But the big question really is, what is an organized grouping of employees? And does it have its principal purpose, the carrying out of the activities concerned on behalf of the client? Now, in 2013, I believe, Eddie Stobart's Limited had a claim relating to this, which obviously is particularly relevant here. Essentially, without giving too much of the detail of the claim, what was held by the Employment Appeal Tribunal, Eddie Stobart's were arguing that TUPE applied, in fact, when some of their contracts moved. But essentially, the Appeal Tribunal, after the original Employment Tribunal, agreed with the Employment Tribunal that there wasn't a TUPE transfer where the employees were carrying out some specific work for the client, but the reason that they were assigned to that contract work was more to do with the shift patterns than a deliberate intent for those workers to be an organized grouping for that client. So essentially, the employees must be organized in some sense by reference to the requirements of the client, rather than by reference to a combination of circumstances, things like shift patterns or working practices on the ground. So if you've got some workers, some employees, I should say, who are working on the XYZ limited account, then and that contract transfers, then those will be an organized grouping for that contract. But if they happen to be working on some or mostly XYZ limited work, because it's day shift work and they happen to work the day shifts each week, then the likelihood is they probably wouldn't be a TUPE transfer of those employees. And this was quite damaging for Eddie Stobart, because they'd anticipated, obviously, that these employees would transfer when they were losing that contract. And so they hadn't anticipated they were going to have a surplus of employees to carry on the work that they still had. And so redundancies were made, I believe. That's the risk here. If the contract is lost, the employees won't necessarily transfer across to the contractor. So in which case, if you're losing a contract or removing a contract and it's going to another contractor, for example, or it's being insourced back by the client, then that's something to seriously consider. The opposing thing to consider is if you are we'll talk a little bit about it, but if you're TUPEing employees into, if you're gaining a new contract, then there's a serious consideration to be had for the risks that you're taking on, the liabilities of those employees. There are some certain exceptions. If the client intends that the activities will, following the change, be carried out by the transferee other than in connection with a single specific event or task of short-term duration. So if it's just going to be a very short-term project, then the employees probably won't transfer. Similarly, it won't apply if the contract is mainly for the supply of goods, I should say. Obviously, that's a bit different in the warehousing sector, where what you're supplying is the services rather than the goods. So what are the legal consequences of the transfer? As you can see, the employees transfer across with a nice little animatic. The transferee inherits the rights, duties, powers, and liabilities of the employees who transfer from the transferor. And so it's very important, obviously, that the transferee is aware of what those are, and continuity of service is also retained for those employees, so that they continue to have a potentially lengthy service. And if you're considering redundancies further down the line, then redundancy payments may be more, and there may be more risk of unfair dismissal claims where people have more than 2 years service. The contract of employment terms must remain the same. Essentially, that is the whole concept of TUPE. And both parties, the transferor and the transferee, are jointly and severally liable for failure to inform and consult, which I will talk about in a minute. There is no transfer of criminal liability, however, which I'm sure you'll be pleased to hear. So what does the transferor need to consider pre-transfer? They want to identify which employees will be affected by the transfer. They're going to want to request information from the transferee, and that's to do with what the transferee intends for those employees. Are they going to work in the same location? Are there any changes anticipated? As I say, you can't change contract terms, but there may be logistical changes that are required, shift pattern changes, things like that, that may affect those employees. And the transferor has to provide something called employee liability information at least 28 days before the transfer. They provide that to the transferee. There are specific formats to doing that. And that includes details of the employees who will transfer, their ages, information in their statement of particulars, any collective agreement information, any disciplinary action that's proceeded within the last 2 years, instances of any grievances, and any legal action. And clearly that's so that the transferee has a better understanding of what liabilities it's taking on, which may affect, of course, the price of contracting. They have a duty to comply with the information and consultation regulations, so which I will cover in a minute. This is the duty to inform. Now, there's always going to be a duty to inform, and you need to inform those employees affected about the transfer date or the proposed date and the reason why, the legal, economic, and social implications of the transfer, and any measures that you envisage. And usually it's the transferee, I suppose, that envisages measures, but they will pass that information to the transferor. When do you need to inform the affected employees? It's one of those excellent grey areas of the law. In good time is essentially the answer. There's no minimum prescribed limit then, but it does depend, I think, somewhat on the extent of the change, any changes that are likely to take place. If there's going to be a lot of measures where shift patterns are changed, locations changed, things are going to change for the employee, then the more time you've given them, you've informed them in advance, the better. And who's entitled to receive that information? Well, it'll either be trade union representatives or employee representatives. Obviously, you can notify employees individually as well, but there needs to be an elected representative. If there isn't a trade union rep, then there may need to be elections for employee reps. And then the duty to consult. Now, I suppose the important thing is they're not the same duty. And you don't always need to consult. If the relevant employer envisages that there's going to be measures taken place in connection with the transfer, then that is when the duty to consult arises. And parties don't need to reach an agreement actually on whether there should be a duty to consult. If the transferee doesn't agree there's a duty to consult and the transferor feels that they ought to, then they ought to do it. And what if you fail to inform or consult? Well, the risk is ultimately that of claims for up to 13 weeks of uncapped pay per affected employee. That can add up. If you've got 40 people transferring, 100 people transferring, that adds up pretty quickly. There's no eligibility requirements as well, so it's, they don't have to have had 2 years service like with an unfair dismissal claim, for example. But the tribunals will consider it on a just and equitable basis depending on the seriousness essentially of how affected the employees are, and it's intended to protect their pay. The transfer is still effective, so if you're the transferee, then you've still got those employees as well. So you'll appreciate it's not necessarily the best start with employees transferring to you and immediately having to deal with claims from them. And then this is what the transferee may want to be considering, and some of that is the same because they also have that duty to consult, as you've seen. They will want to obtain information on affected employees, including, and really that's the employee liability information which they'll get from the transferor. And that's where I think consideration of any warranties and indemnities in the contracts ought to be discussed and worked out. Now, you can't contract out of TUPE. It is a statutory setup so that ultimately, even if the parties said to themselves, both the transferor and transferee said, we don't think TUPE applies, if an employee protests and brings a claim in the tribunal, for example, the judge will make a decision regardless of, even if you put a contractual term in saying TUPE does not apply, it will be overridden if the judge considers that the definitions that I set out earlier on the service provision change, for example, applies. So for that reason, the transferee particularly will want to make sure that there's some indemnities in place so that they're not taking on unexpected liabilities. You'll want to inform the outgoing employer, the transferor, of any measures you propose As I've said, the transferor will also consult on those with the employees affected. And you want to identify any contractual benefits and so on. If there's additional contractual benefits, that's obviously maybe more of a sweetener for the employee anyway. And I do think it's important to have good communication with those affected employees. Sure, they're not your employees yet, but they're about to be potentially. And it's certainly helpful for the process if the transferor and the transferee maintain good communication between each other and with those employees affected. So the next steps. What if you want to dismiss an affected employee? Well, it will be automatically unfair if the sole or principal reason for dismissal is the transfer. That's the scenario you want to avoid. There is a defense. If the dismissal was for an economic, technical, or organizational reason, then there may be a defense, but it must entail a change in the workforce. And even if there is a defense, it only means that the dismissal isn't automatically unfair. It can still be found to be unfair on the usual principles of unfair dismissal claims. So all economic, technical, and operational. Economic, relating to the profitability or market performance. Technical, equipment or production, and operational, management or organizational structure. Now, I don't intend to go into this in detail. Obviously, you can read these slides later. But as I say, the important thing is those reasons need to essentially require a change in the workforce. For example, you need to change the number of employees or change the structure of your employees so that the restructuring as you're taking in these new employees. And that would be your defense to that automatic unfair dismissal claim. As I say, there's still a risk of a normal unfair dismissal claim. What about if you want to vary contractual terms? Well, you're still running an unfair dismissal risk, because the whole principle of the TUPE provision is that employees transfer on the same terms. They are entitled to insist on all rights under their old contract. So any change to terms and conditions will be void if the sole or principal reason is the change itself. But again, if there's an ETO reason, that's your protection. Even then, you will want to make sure that you have properly consulted with those employees and essentially obtained their consent to the changes. Now, there may be some changes to the legislation on this down the line, which I'll discuss in a few slides' time. What about if an employee objects to the transfer? They have the right to object, maybe, and there are often good reasons, and often it's to do with relocation. Now, that's probably not a problem if you're in a multi-party warehouse. You know, so literally they're changing high-vis jackets and changing employer and doing the same job. But where you've got warehouses different parts of the country, then obviously that's a serious consideration for those employees. Do they want to transfer? And even more so if it's an international transfer. So if they object, then essentially it's a dismissal. It will be treated as a dismissal. And essentially like a redundancy. So an employee can resign without notice where there is a fundamental change to the terms and conditions of their contract, and that would be potentially a constructive unfair dismissal. Again, claims ideally you want to avoid, although a more difficult claim for an employee to win, as the burden of proof shifts to them. They need to show that there's been a fundamental change to the terms. And similarly, if there's substantial changes to their working conditions to their detriment, that's not a fundamental, if that's not a fundamental breach of contract, it's still a dismissal, and there's a risk again of an unfair dismissal claim. Or I suppose, thinking about it, there's always risks if those changes to contracts might affect protected characteristics, like someone with a disability, or for example, if it unduly affects all female employees or all male employees, then there's a risk of discrimination claims as well. So that's always a factor to consider into this. And those are the main things to consider with TUPE for a service provision change. Obviously, it's a bit of a whistle-blown, sorry, not whistleblowing, but whistle-stop tour of the main issues there and the main provisions. The things to consider for warehouse workers, you know, for warehouse development and so on as well. And I think ultimately it is something that it's not just an HR function. It's not just something to think about at the last minute, especially you're taking on a new contract. You want to know what are the risks and liabilities that you're taking on? Who are the employees that you're taking on? You know, what are they going to fit in fact, if you are going to consider making any redundancies? What are the effects there? So there's a lot to consider. And honestly, TUPE, I think, works pretty well for larger organizations, especially in warehousing. Like I say, if you're in a multi-party big warehouse chain, then it's a relatively straightforward process. I think it can be more tricky for the smaller and medium-sized organizations. And that's where really, there needs to be some serious consideration before you're getting to the TUPE transfer date. It's a key commercial issue. But the question then is anything going to change with Brexit, or has anything changed? Well, no, at the moment it hasn't. The main provisions and principles remain. However, there does seem to be some indication that the government will vary it to enable employers to harmonise terms following a TUPE transfer, meaning you may be wanting to make sure that your new employees are on the same contractual terms as your existing employees. There will still be risks there, I think, if that is made legislation. I think if you're changing fundamental terms, there's always a risk that there's still a fundamental breach of the incoming employees' contracts. And it may be that what you're doing is in fact reducing your existing employees' contracts to harmonize things. Again, until that happens, until the government put it in, it's a little hard to predict what may occur. They did do a consultation in 2013, but there haven't been any changes come out of that yet. So at the moment, everything stands as it is, and really those are the key points to consider with service provision changes particularly. So I don't know if anyone has any questions, but hopefully I've covered some of the main things you want to consider, and I'm always happy for people to contact me after, or if you're watching the recording back, to contact me directly, so I can answer any questions or give you some legal advice if required.
Wow, well, thank you ever so much, Michael. That was really interesting. I hope you won't mind, but I do have a question, because
yes,
in my previous working life, I've come across TUPE, and I seem to recall that there was some kind of exemption around pensions, that perhaps under the rules of TUPE, you don't always have to honour the pension of the incoming person. Do you think that's right?
Yeah, so it depends on the type of pension. There are two main types of pension. Obviously, employers will either have their own occupational pension scheme, or they'll pay into a personal pension schemes for each employee. If it's an occupational pension scheme, then the pension itself won't transfer. Part of the employee liability information will be pension information. Part of the measures, or the kind of the correspondence that you give to the employee reps or the trade union reps, will be information about the new pension scheme. So essentially, because you can't just transfer, the pension is held by the transferor, and then the transferee will have their own pension scheme. So the employees will transfer over. Either they can keep their existing pension pot, or they can transfer over as when anyone changes jobs. If it's a personal pension scheme, payment into personal pension scheme, however, that will transfer or can transfer. Yes, you're right, and it's something that needs to be spelled out to the employees. If it's an occupational pension, then there will be some changes, albeit obviously most pension schemes operate on pretty much the same basis. It will be just a different provider. I'm trying to think if there's anything else. The only other exceptions as well apply more to business transfers, really, where business is insolvent. There are exceptions then to employees' rights transferring, depending on whether it's a complete winding down of the company or whether it's a sort of administration. There are different levels of exception from the rules, but that applies more for a business transfer, where essentially a transferee is swooping in and rescuing those employees who would otherwise be made redundant by an insolvency.
Mm-hmm. Okay,
yeah.
well, as per usual, it's a little bit more complicated than I expected, and I suppose that's a good note for me to mention how glad we are to have the support of Aaron's. I know you run a legal helpline for members of UKWA, and anybody contemplating this kind of scenario would be well advised by UKWA to make use of the helpline that you support us with.
Yeah, I highly recommend that. I mean, obviously, TUPE is something that I think comes up probably quite often within these kinds of contracts where they're shifting hands fairly regularly. But it's still something that needs to be considered in advance. As I say, especially if you're taking on the new employees, if you're the transferee, you don't want to be taking on liabilities and risks you're not expecting. Equally, if it turns out that both parties think there is a TUPE transfer, but there isn't, that a judge determines that there isn't actually a transfer, then, as I say, you may be stuck with employees that you weren't expecting. If you were expecting employees to transfer out with the contract you've lost or that's gone to another party. So there are always a lot of things to consider, and it is a commercial factor. And I have seen companies unfortunately quite seriously affected by just not having that planning in place in time.
And with the labour shortages that we're currently facing in our industry, it may be that the dynamic is changing somewhat, in that the transferee would be quite hopeful of getting the staff, because irrespective of those terms and conditions, if there are labour shortages, it can be difficult to fill that up if you haven't got sufficient people. And of course, people transferring are often those who know the customer and know the contract and the business quite well, and they can be a real asset.
Yeah, I think I absolutely agree with that. And it obviously it can be really helpful for the client. The client has a consistent, organized grouping of workers who are working on their contract and knows what they're getting. They're not suddenly getting a whole new load of people who maybe have to train up a little bit on whatever that contract involves. And I think you're right as well. In the current climate, where staff shortages are becoming increasingly a big issue, it may well make total sense. And to a certain extent, I suppose it can give people, organizations tendering for work, a little bit more protection and assurance that they're going to be able to meet the contract they're tendering for, if they know that there's a TUPE transfer in the background, that they're not having to make sure that they can make up the staff with the staff they've already got, or with new recruitment, but with staff who will transfer over, that know the job, that know the client. So which is why I say I think it works really well most of the time, but it can be there can be some serious pitfalls there. And I think the smaller organizations, the smaller employers can get caught out, and I think the one other thing is, I think I didn't mention, is in the interim period while the TUPE is going on and while there's consultation and so on, obviously there's a risk of a lack of engagement in the workforce, and that that is where I think often where there's a grouping of workers are servicing a number of clients, and so that's something that's to look out for as well, to try and continue that engagement with your workforce. If your employees are contracting out, about to be TUPE'd over to another employee, to another employer, you don't want them to lose focus on what they're doing. And so if they know that they're transferring on good terms, if they know that they're transferring on a project, on work that they know what they're doing, then they're more likely to keep up what they're doing and work, continue to work consistently.
I think in any change management process, it's usually you're well advised to over communicate, whatever change management it is.
Yeah, I mean, I have to say, I think obviously I spend a lot of my time advising people on different types of consultation, whether that's large scale redundancies or TUPE and so on. And I am very much of the view personally that communication is key, that there's no point keeping your employees in the dark. Obviously there's a threshold to be had there, where you don't want to be alerting or worrying employees where you're not even sure whether there's going to be a transfer or redundancies, and so I think at the point where you announce this is what's likely to happen, then having a seriously good consultation actually can be really key to keeping that engagement, and making sure your workforce continues to be happy. Or if you're the transferee, making sure that the new employees that you're about to get are happy, because they know what to expect, and they don't turn up and find everything suddenly shifting.
Great. Well, I suspect, Michael, that you and I could talk about this topic for a lot longer. But as you say, it's a bite-sized session. I think you've covered it really well, and I'm very grateful that you've explained it for our members. The webinar is going to be available on our website indefinitely, I suppose. So thank you very much, Michael. Thank you to everybody at Aarons, and goodbye to our audience.
Thank you very much.